also like to thank the members of the international expert panel. They are some of the most experienced and best minds in neonatology in the world today. And they are incredibly busy people who have given freely and generously of their time to this effort to uncover the truth. And they have done so with objectivity and impartiality, knowing that regardless of whatever they say, whether it's favorable or unfavorable to Lucy, it would be released, because they did not come into this to free Lucy, they came into this to discover the truth. Finally, we hope the authorities will consider our findings seriously and act accordingly, because you will not find a better panel of experts anywhere in the world. And today is actually a historic day, because it is possibly the first time that a group of the top minds in neonatology in the world have come together voluntarily and pro bono to provide clarity to some very vexing questions about a troubling case. If you are looking for the truth, you don't need to go any further.
A shocking revelation has emerged in the case of Lucy Letby. A panel of 14 internationally respected experts working independently pro bono with no motive but the truth has reviewed the medical evidence in the case. Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In today's video, we will explore the latest developments in the Lucy Letby case and the shocking revelations brought forward by a panel of 14 independent experts. These professionals, with no financial incentive, insist that their only motivation is the pursuit of scientific truth. These experts, renowned in their fields, dedicated their time voluntarily, free from any court influence, driven solely by the demands of scientific integrity. Their only motivation was the pursuit of truth through science. This video is structured into three main sections: the composition of the panel and what their findings reveal, are we dealing with fresh evidence, and what actions should the legal system take next, and how is this case expected to progress. As you know, in many of our videos, we begin with key preliminary points to provide context for the discussion. Today, we have three important ones. First, as we have reiterated on numerous occasions in our coverage of the Lucy Letby case, we fully recognize and respect the fact that this case involves real people, particularly families who have suffered unimaginable loss and trauma. Every time this case is revisited, it undoubtedly causes further distress to the parents of the children who tragically lost their lives and the survivors who endured such a traumatic event. Our deepest respect goes to all those affected. Indeed, the expert panel led by Dr. Shoo Lee have the same respect and have acknowledged the family's distress, which they have addressed as follows.
I'd like to share the sympathies and condolences of members of the International Expert Panel with families of the affected infants. We understand their stress and their anguish, and our work is not meant to cause more distress. Rather, it is meant to give them comfort and assurance in knowing the truth about what really happened. We know that they want to know the truth, and that is why we are here, to tell the truth. Should they have any queries or concerns, we'd be pleased to discuss them with them.
Second, we acknowledge that this case also concerns a real individual who is currently serving a life sentence. If the conviction is correct, then justice has been served. However, if there is reason to doubt the verdict, then we must confront the very real possibility that an innocent person has been imprisoned for life. An outcome that is equally unjust and deeply troubling. While we understand that revisiting this case may cause significant distress to those involved, the pursuit of truth and justice demands that these discussions take place. However, they must be conducted with the utmost respect for everyone affected. Our goal is not to sensationalize, but to critically examine the facts in the interest of justice. Finally, while we will briefly examine the composition of the expert panel and summarize its key findings, this will only serve as a context for our primary focus, the legal implication of this case. Given that we do not have the necessary medical expertise to analyze the panel's conclusions in depth, we will not attempt to interpret their scientific findings beyond what it is relevant in our legal discussion. This channel, as you know, is dedicated to scrutinizing the criminal justice system, and our focus here is to evaluate whether the system, as it currently operates, has the necessary safeguards to identify and address potential miscarriages of justice. If errors have been made in this case, we must ask, does the system have the right mechanisms in place to correct them? And if not, what must change to ensure that justice is truly served? Our analysis will center on whether the Criminal Cases Review Commission and the Court of Appeal are equipped to fairly and thoroughly reassess cases like this and whether their processes are fit for purpose when confronted with compelling new evidence. I appreciate that this was a lengthy introduction, but I hope it has clarified the focus of our discussion. Before we dive in, one last reminder: if you haven't already, please hit the subscribe button below. Your support enables us to continue delivering in-depth analysis of the criminal justice system, exploring how its structure impacts real lives, and fostering important discussions that can drive meaningful reform. So let's start with the panel. As we all know, on the 4th of February 2025, during a press conference organised by Sir David Davis and Mark MacDonald, Lucy Letby's newly appointed barrister, Dr. Shoo Lee, Professor Emeritus at University of Toronto, announced that he had assembled a sort of blue ribbon committee to reassess the medical evidence presented at Letby's trial. A blue ribbon committee, as you probably know, is a group of exceptional people appointed to investigate, study, or analyze a given question. Dr. Shoo Lee provided a brief background explaining that after testifying in Lucy Letby's appeal last year, he became concerned about the medical evidence presented both at trial and during the appeal process. As a result, he proposed to the defense that he would assemble an international panel of experts to independently review the evidence and produce a report, regardless of whether the findings were favourable or unfavourable to Ms. Letby. Ms. Letby agreed to this approach. The objective was to create an impartial, evidence-based report on the deaths and/or injuries of all the infants involved in the trial, using the same medical records and expert witness statements that were originally presented in court. The panel was instructed to 1. Review the medical records to determine the causes of death or injury, examine and critique the expert witness statements and the medical opinions presented at trial, and 3. Produce a comprehensive report on the medical findings. Each case, Dr. Shoo Lee told us, was reviewed by 2 independent experts. If their conclusions aligned, their findings were accepted as final. However, if there was a discrepancy between their assessments, a third panel member would be brought in to review the case and help establish a consensus opinion. The panel included 10 neonatologists, a pediatric surgeon, 1 pediatric infectious disease specialist, 1 senior neonatal intensive care nurse, and 1 other pediatric specialist. Dr. Shoo Lee explained that he intentionally selected specialists from around the world, including the UK, US, Canada, Germany, Japan, and Sweden, to ensure that they had no prior exposure to or influence from the case, thereby maintaining the highest level of objectivity and impartiality. The panel was also aided by 2 external experts in engineering for information about insulin and C-peptide testing, who were under the instructions from Ms. Letby's defense team. The panel reviewed all 17 cases for which Lucy Letby was convicted, assigning each a number from 1 to 17. However, during the press conference, Dr. Shoo Lee provided only a summary of select cases, as presenting a full analysis of all 17 would have been too time-consuming. In his summary, he compared the prosecution's asserted cause of death with the panel's findings. He also addressed a critical misuse of scientific evidence in the trial, highlighting that a 1989 paper he co-authored, which was relied upon by the prosecution, had been misinterpreted. He clarified that the skin discoloration described in that study was linked to arterial air embolism, not venous air embolism, the latter being the mechanism proposed by the prosecution. To correct this misunderstanding, he published a new paper in 2024 where he distinguished between venous and arterial air embolism. His key finding was that venous air embolism, central to the prosecution's argument, does not cause skin discoloration, directly contradicting a major claim made at trial. The first key point he emphasized was therefore that the claim that infants collapsed and exhibited skin discoloration as evidence of air embolism is scientifically unfounded. The panel concluded,
In summary, ladies and gentlemen, we did not find any murders. In all cases, death or injury were due to natural causes or just bad medical care. Lucy was charged with 7 murders and 7 attempted murders. In our opinion, the medical evidence doesn't support murder in any of these babies, just natural causes and bad medical care. Our full report will go to Lucy's barrister later this month, and then it'll be up to him and the courts to decide what next to do.
In our view, the panel's findings appear clear, presented with certainty and full confidence. And finally, to conclude this first part of this video, this is what Dr. Shoo Lee said about Dr. Evans.
Dr. Evans, I don't know him either, and you tell me that he hasn't published anything. If you look at this panel, there's probably about 500 person-years of experience with all these people. These are the heads of units of the top institutions in the world. So I would trust their judgment. When it comes to Dr. Evans' testimony and his opinions, I would ask you to ask 3 questions. First of all, the first question would be, if our panel found so many problems with the medical care provided by this team at this hospital, how is it that Dr. Evans found none? Because in none of the 17 cases did he even identify one problem with the medical care provided at the hospital. The second question I would ask is this. He seemed to be rather selective his use of information. So if he wasn't selective, if all the information was used, in fact, you would come to a very different conclusion than what he came to. Just take, for example, the case of the hypoglycemia, where he said there was no sugar for 2 hours and the blood sugar grows, therefore it must be insulin. In fact, he missed the one important value, which was at 1146, showing that the blood sugar, in fact, did not rise. So was he just careless, or was it deliberate? The next question that I would ask is, even when there's an obvious cause of death, why did he go around looking for malfeasance? So I would ask you to ask these 3 questions and ask Dr. Evans that. If you can answer those 3 questions, I think you have the answer to your question.
In essence, Dr. Shoo Lee concluded that Dr. Evans had been selective in his assessments, a criticism that notably is not new. In fact, in December 2022, Lord Justice Jackson took the unusual step of writing to Judge Goss, warning him about Dr. Evans' unreliability in a previous case. The question now is whether this will finally prompt the Court of Appeal to recognize the issue with Dr. Evans' credibility, especially given the recent shift in his expert opinions on some of the cases, as we have highlighted in this video. This naturally brings us to the second part of this video. So where will these findings lead the Letby case? It is understood that a preliminary application was sent to the CCRC as announced by the CCRC on the 4th of February 2025. The announcement confirms that work has begun to assess the application and that further submissions are expected. The Commission goes on to say it is for the CCRC to find, investigate, and, if appropriate, refer potential miscarriages of justice to the appellate courts when new evidence or new argument means there is a real possibility that a conviction will not be upheld or a sentence reduced. At this stage, it is not possible to determine how long it will take to review this application. A significant volume of complicated evidence was presented to the court in Miss Letby's trial. So Miss Letby's first hurdle is to convince the CCRC to refer the case to the Court of Appeal. As of December 2024, the CCRC has received a total of 32,758 applications since its inception in 1997. Out of these, 855 cases have been referred to the appeal courts, resulting in a referral rate of approximately 2.6%. This indicates that the CCRC refers a small percentage of the cases it receives to the Court of Appeal, highlighting the rigorous standards applied to the referral process. The CCRC only refer cases where there is a real possibility that the conviction or sentence will be overturned, making the bar for referral extremely high. We have discussed the real possibility test in many of our videos, and more recently in our video, the CCRC under the spotlight, multitasking or mismanaging, in which we concluded that perhaps rather than focusing on amending the real possibility test, the only way to properly address wrongful conviction is providing the Court of Appeal with broader powers to quash a conviction when it has serious doubt about the verdict, even in the absence of fresh evidence or new legal argument. The CCRC's approach to referrals has come under intense scrutiny, most notably in relation to its handling of Andy Markinson's case, where Mr. Henley KC conducted a thorough and critical review. While we previously discussed the limitation of Mr. Henley KC's report in our video rebuild or reform Mr. Helighese's finding on the Criminal Cases Review Commission, one of his most significant conclusions was that the CCRC was failing to properly apply the real possibility test when deciding whether to refer cases to the Court of Appeal. Mr. Helighese argued that the test should be interpreted as follows. The Court of Appeal will quash the conviction if it concludes that the jury's verdict might have been different had they heard the new evidence due to its potential significance, thereby rendering the conviction unsafe. Applying this standard to Lucy Letby's case, the caliber and credibility of the international panel chaired by Dr. Shoo Lee cannot be ignored. Had the jury been presented with these expert findings, it is highly unlikely they would have dismissed them. This raises a compelling argument that the CCRC must recognize the significance of this new evidence and refer the case to the Court of Appeal. However, even if the CCRC refers the case, Ms. Letby still faces significant hurdles. Before the Court of Appeal can even consider whether the new evidence renders the convictions unsafe, it must first determine whether the evidence is admissible under Section 23 of the Criminal Appeal Act 1968. What does Section 23 say? Section 23 gives the Court of Appeal the power to receive new evidence in an appeal, but it does not guarantee automatic admission. Instead, the court must consider 4 key factors. Whether the evidence is capable of belief, the court will assess whether the new evidence comes from a credible source and whether it is reliable. In our view, the panel, chaired by Dr. Shoo Lee, consists of highly qualified experts, which strengthens the argument that their finding should be considered credible. The court will also consider whether the new evidence could have been obtained earlier with reasonable diligence. These involve assessing whether the defense had access to similar medical evidence at the time of the original trial. If the defense could have reasonably sought expert opinions but failed to do so, the court may be reluctant to admit the new findings. However, if the new evidence challenges specific assumptions that were not properly examined at trial, it has a much stronger case for admissibility. Dr. Shoo Lee clarified that the misinterpretation of his 1989 paper only became evident to him during the appeal process, meaning this misunderstanding was not apparent at the time of trial. Given that the defense could not have diligently identified this issue earlier, this should provide justification for why the evidence was obtained at a later stage and strengthen the argument for its admission. Thirdly, it must consider whether the evidence is relevant to the case. The new findings must have a direct bearing to the safety of the conviction. Given that Lucy Letby's case heavily relied on medical expert opinion, a significant challenge to that opinion is clearly relevant. It is important to note that the key factors in Section 23 must be given specific consideration. They are neither exhaustive nor conclusive. The new evidence must be primarily admitted if it is in the interest of justice. The court must admit it if it is in the interest of justice to receive it. In the case of Regina v. Erskine and Williams, Lord Judge C.J. said virtually by definition the decision whether to admit fresh evidence is case and fact specific. The discretion to receive fresh evidence is a wide one, focusing on the interests of justice. The consideration listed in subsection 2a(d) are neither exhaustive nor conclusive, but they require specific attention. The fact that the issue to which the fresh evidence relates was not raised at trial does not automatically preclude its reception. However, it is well understood that, save exceptionally, if the defendant is allowed to advance on appeal a defense and/or evidence which could and should have been, but were not put before the jury, the trial process will be subverted. Therefore, if they were not deployed when they were available to be deployed, or the issues could have been but were not raised at trial, it is clear from the statutory structure, as explained in the authorities, that unless a reasonable and persuasive explanation for one or other of these omissions is offered, it is highly unlikely that the interests of justice test will be satisfied. We are of the view that in light of the arguments presented, the new evidence meets the criteria under Section 23. However, the hurdle does not end there. At this point, the Court of Appeal will then have to move on to the next stage, namely determining whether the conviction is unsafe. In paragraph 189 of the first application for leave to appeal, the court concluded that the prosecution witnesses based their opinion on the premise that they made findings consistent with their embolies, which collectively could not be explained by natural causes or any other possible alternative explanation. However, the international panel's report provides the very alternative explanation that the prosecution witnesses failed to identify, fundamentally challenging the basis of their conclusions. In other words, the expert panel's findings directly contradict the medical evidence presented at trial. Given the factors we analysed earlier, most notably the panel's composition, which includes some of the world's most experienced and distinguished neonatologists and pediatric specialists, the panel's approach, which is beyond reproach, it was conducted with the highest level of independence, free from financial incentives or external influence. Their sole motivation was the pursuit of truth. Furthermore, the integrity of their review is reinforced by the fact that most of these experts had no prior involvement in the case, and some, being from other countries, were previously unaware of its details. This minimized the risk of bias or contamination, ensuring an objective and impartial assessment. In light of all of this, it is a reasonable conclusion that the Court of Appeal may determine that this fresh medical analysis undermines the original verdict to such an extent that the conviction can no longer be upheld. Can we be absolutely certain of this outcome? Of course not. However, it is certainly a possible outcome. The CCRC and the Court of Appeal face a defining moment. Will they acknowledge this overwhelming new evidence, or will they ignore the very foundation of justice? Just as this panel of experts was driven solely by their commitment to science and truth, we expect the CCRC and the Court of Appeal to approach this case with the same unwavering dedication, guided by one principle and one principle alone: the pursuit of justice. Their decision should not be influenced by external pressures, past verdicts, or institutional reluctance, but by the fundamental duty to ensure that justice is served based on the most accurate and reliable evidence available. It is clear that the recent developments in this case highlight more than ever the urgent need for fundamental reforms in how we handle complex medical evidence during trials. The way trials are conducted, particularly when dealing with intricate issues such as medical expert opinion, must be re-evaluated and carefully reconsidered. There are several potential changes that could be considered, including revised methods for appointing medical experts, ensuring that those who serve as experts are not only qualified but also impartial. The possibility of having expert panels first vetted jointly by the court, along with input from both the prosecution and defense, to ensure that the selected experts are truly neutral and competent. Or providing specialized support for juries, helping them better understanding the complex medical information they are required to evaluate and ensuring they can make more informed decisions. These are critical issues that certainly demand urgent attention. However, they are beyond the scope of today's discussion. This is a topic that we most likely will revisit in a future video, perhaps after the Lucy Letby appeal has been heard. By then, we will have a better understanding of how the Court of Appeal decides on the case and whether the current system is adequate in providing just solutions in complex cases such as this. I hope the issues we have discussed today have sparked your interest. I look forward to reading your comments and encouraging a robust discussion that generates new ideas and potentially paves the way for reform. If you haven't already, don't forget to subscribe to help us continue the conversation about the shortcomings of our criminal justice system with the aim of finding realistic and feasible solutions. Join us again as we sit and rise in this unique trial.